Welcome, everyone, to the Administrator Essentials School Law 101, brought to us by Miller Johnson. I'm Rebecca Peck. I am the president of Michigan Negotiators Association, and we appreciate everybody that is logged in today. This session will be recorded, and it will be distributed to you after this session. I would very much like to introduce you to Mr. Bob Schindler. Bob is an attorney, an education attorney with Miller Johnson. He has been in this business for many, many, many years. I don't want to age you. Was that one too many manys, Bob?
No, it was okay.
Bob started off as a teacher, which we love about Bob because he understands boots on the ground, that work in the classroom and the impact it has on students and learning, and how to connect with families and students. So that's where he got his start. Moved then on to he does have a law degree. So he does have a law degree. He moved into another organization, Lusk Albertson. Coming out of Lusk Albertson, they merged with Miller Johnson, and he is with us today. I've had a great opportunity to work with Bob many times in my career. He has helped me out in so many situations. He is a great teacher, leader, and lawyer. So with all that said, Bob, take it away.
Thank you, Rebecca. I appreciate that. Good morning, everyone. So today we're going to be talking about Administrator 101. A couple of points. I know Amy put it down below, but if you have questions, thoughts, comments, you want to discuss a real world scenario, and that's a little bit harder sometimes in a webinar format, but if you have questions, put them down in the Q&A. I'll be trying to check that at certain points, and Rebecca will be watching it as well. So that way, if there are questions or issues about what we talk about, we can address it. And I'm happy to do so. In fact, I prefer it when we have some dialogue. So today we are talking about Administrator Essentials. And what does that mean? Well, we're going to talk about a few main points. One being teacher staff expression rights, First Amendment issues, that sort of a thing. We're going to talk about how that relates to social media and social media in general, and sort of dealing with social media. It is obviously a big and constant topic now. We're going to talk about investigations. Something goes wrong, you have to do an investigation. What are some basic do's and don'ts, some points to think about, how to conduct yourself in that process. We're going to talk about the GTLA, or the Governmental Tort Liability Act. This has been obviously a big concern, or liability has become an even bigger concern in sort of a post-Oxford Schools world, where we're seeing administrators and counselors and all kinds of people get sued. And I know it's created a lot of fear amongst educators. And so I want to talk a little bit about what the law actually says there and how you're protected in your decision-making process. And I also want to talk about the processing of grievances, because if you're an administrator of some kind, that means you're probably overseeing employees. And if you're overseeing employees, you're probably dealing with grievances in one way or another, whether that's in step 1 or step 4 of that grievance process. So I want to talk about grievance processing as well. Along the way, we'll get into things like the First Amendment, Weingarten rights, liability, and all those sorts of things as well. So, all right, first, let's talk about teacher or staff expression. So I don't always, when I do cases, when I do presentations, like to get sort of bogged down into case law. But what I find when it comes to the First Amendment, looking at specific cases is extraordinarily helpful. One, because it gives us some facts to think about, but two, it really gives us the framework on how to analyze these issues. And that's, when it comes to First Amendment, there is never a black or a white answer. There is always considerations. And so thinking of the cases helps us understand the considerations that we need to make when it comes to these issues. So when it comes to public employee speech, especially education, the The landmark case is a case called Pickering versus Board of Education. This is really the first public employee free speech case, First Amendment case. Happened in the 1960s, 1968, the U.S. Supreme Court decides it. And what happens here is that Mr. Pickering is a teacher, and he's a high school teacher. And the school district that he works for is in Illinois, and they're going up for a bond issue. They're having a public vote for a bond. And Pickering uses, as I like to say, he uses the social media of his day, of the mid 1960s, which is he writes a letter to the editor of his local newspaper. That letter is published in the local newspaper. And in his letter, Mr. Pickering basically says he encourages citizens not to vote or to vote no on the bond. And his position is, last time there was a bond vote, the board said they were going to put all of this money into the classroom, and instead they spent it on sports facilities and other things like that. I don't really trust them that they will do this properly. And I don't think you should trust them either. And as a result, I'm recommending you vote no. So that, of course, went over with his board like a lead balloon. He was terminated based on this letter, and he filed a lawsuit in Illinois State Court asserting this was a violation of his free speech rights. He filed it under both the Illinois and the U.S. Constitution. The case goes all the way up to the Illinois Supreme Court, and each court along the way holds in favor of the employer and says, nope, sorry, no free speech rights. You're a public employee. You're talking about your employer. And as a result, they can terminate you. It goes to the U.S. Supreme Court after that, and the U.S. Supreme Court disagrees, and they find in favor of Mr. Pickering. And what they say in there, that they create what we now refer to as the Pickering balancing test. And what they say is the problem in any case is to arrive at a balance between the interests of the teacher as a citizen in commenting on matters of public concern and the interest of the state as an employer in promoting the efficiency of the public services it performs to its employees. The court then goes on to state, statements by public officials on matters of public concern must be accorded First Amendment protection despite the fact that the statements are directed at their nominal supervisors. And then sort of the final important quote here is that they say, in a case such as the present one, in which the fact of employment is only tangentially and insubstantially involved in the subject matter of the public communication made by a teacher, we conclude it's necessary to regard the teacher as a member of the general public that he seeks to be. So, some really important points to come out of this. The first one, in this first paragraph, what we see is this idea that if a public employee is speaking as a citizen on a matter of public concern, so sort of two parts to that, speaking as a citizen and speaking on a matter of public concern. If they're doing that, then that speech is generally protected by the First Amendment. Then, if we have that situation, those two things are met, now we do a balance. And we say, okay, now we need to balance the rights of that employee to engage in First Amendment protected speech versus the rights of the employer. And whichever way the balance tips, that's where we go with it. So in this case, what they say is the balance tips in Pickering's favor. And it does so for a few different reasons. In the second paragraph, it makes this point that the protections, despite the fact that his statements are directed at his nominal supervisors. So what the kind of court says here is, look, in this case, he's writing this letter. It's aimed at the Board of Education. The board's upset about it. Ultimately, yes, if you look at the org chart, right, the board is over everyone. But these are not really his supervisors, right? He doesn't work with the board on the day-to-day in his job. Heck, if it's a large enough school district, the board might not even have any idea who Pickering is, right? They might not be able to pick him out of a lineup. So, the reality is what they say is this isn't going to disturb the day-to-day operations. And then they get into this last paragraph where they say, in this case, we're talking about an issue that's up for a vote. There's public debate about it, right? The situation is such that if this is something that the citizenry is talking about, and just because this person is a public employee doesn't mean they should be removed from the discussion that citizens are having. In fact, the court says, hey, look, we should want people who are on the inside to be talking about these things because they're going to have more insight. They're going to have more understanding than the rest of us are going to have. So we shouldn't say just because you're a public employee doesn't mean you can't have any comments, especially negative comments about your employer or activities of your employer. And so as a result, the Supreme Court here says, no, the balance does not weigh in the school district's favor. And instead it weighs in the favor of Pickering. What we also know with this, and what we would get into a little bit more, is it leaves open this idea that the balance could tip in the other favor. So if it wasn't his nominal supervisors, if he wrote this letter to the editor and he was blasting his principal, right, or maybe even his superintendent, maybe that changes things a little bit because now there's a more direct employment issue. And now maybe it disrupts, depending on the letter and the content, maybe it disrupts the ability of the organization to do their job, or at least as it relates to him, right, in that relationship. All right, so that was the very first case, 1968. 15 or so years later, in the early 80s, we have a case called Connick versus Myers. Now, this is not a school case. But it is a public employee case. In this case, now we're dealing with lawyers. In particular, an assistant prosecutor for the city of New Orleans. She learns that she's going to be transferred, and she is not very happy about it. She objects to her supervisors, who say, thank you, your objections are noted, but we're going to transfer you anyway. She, again, is annoyed. These lawyers are apparently not in a union, so she can't file a grievance. So instead, what she does is she circulates amongst her fellow employees a questionnaire regarding, and the questionnaire asks questions about their views on office transfer policy, office morale, the need for a grievance committee, the level of confidence that they have in their supervisors, and whether they felt pressure to work on political campaigns. So her employers, her supervisors get annoyed by this questionnaire, and she is terminated. She files a claim saying her termination was in violation of her First Amendment rights. This questionnaire was First Amendment protected speech. This goes all the way up to the U.S. Supreme Court, and the Supreme Court disagrees with her, and this time they fine for the employer. And what they say here is that she was not a citizen talking on a matter of public concern. In particular, they look at that second part on the issue of public concern. And what they say is, okay, yes, things like whether public employees feel pressure to donate to campaigns may be a matter of public concern, but in application here, it was not, right? She wasn't engaging in public debate. She was griping, in essence, amongst her fellow employees about work conditions. This was an employment grievance, basically, right? Like a complaint about her employment and employers amongst fellow employees, and essentially trying to start sort of a workplace issue. And so what the court says is, well, no, you're not acting as a citizen and speaking on a matter of public concerns. You're speaking within your employment context on employment issues. And so no First Amendment protection at all. We don't even have to get into the balancing test because here the First Amendment doesn't protect it. which brings me to I think an important point when we're thinking about constitutional issues. And that is either, we're talking about like the First Amendment, for example, right? Either the Constitution is violated or it isn't, right? Meaning, if they had only given her a 3-day suspension instead of a termination, would that have mattered? No. The question is, if this speech is First Amendment speech, then it's protected, and you can't discipline. If it's not First Amendment speech, you can discipline. Now, there may be other reasons, contracts, or other things that would say discipline is not appropriate, but it wouldn't violate the First Amendment. And that's an important piece. It's either yes, you do, or no, you don't. There isn't really gray here, except for this whole balancing issue. But then we have to look at, okay, yes, there's First Amendment protection, or there isn't still. There's always the question. Same thing goes when we're talking about things like due process or search and seizure rights when we're talking about students, right? Or even student First Amendment speech. It's when we're talking about the Constitution, either it's violated or it isn't. There usually isn't grades of violation, or yeah, you violated, but because it wasn't that bad, you're okay. No, that's not how it works generally. So that's important to understand as well. All right. Last sort of main case on this is a case called Garcetti versus Ceballos. This happens 20 years after Connick versus Myers, 2006, another prosecutor case. In this situation, Ceballos is a deputy district attorney. And basically what the practice was in his area was that if a prosecutor wasn't working on a criminal case, defense attorney could ask them to look into issues like this. So in this case, defense attorney comes to Ceballos and says, hey, I have a client who was arrested and is being charged with a crime, but I think that the warrant was bad. I don't think the police had probable cause for this warrant, and I would like you to look into it because there were inaccuracies in this affidavit that was used to secure the warrant. Ceballos looks at the case. He ends up agreeing with the defense attorney, and he writes this memorandum to his bosses that says, hey, I think that the warrant was bad in this case. I think we should drop the prosecution, because if so, there's a good chance we lose this. And so we should stop. His bosses say, much like in Connick versus Myers, your objection is noted. We disagree. We're going to move on with the prosecution. Thereafter, Ceballos claims he was retaliated against because he was reassigned at one point to a different assignment that he didn't like as much. He was transferred to another courthouse at one point. Thereafter, he was put his name in for a promotion and didn't get it. And he says, look, all of this is happening to me in retaliation for this memo, and that's a violation of my First Amendment rights. Excuse me. Goes up, he sues on this, goes all the way up to the U.S. Supreme Court, and the U.S. Supreme Court ends up holding for the employer again. And what they say here is, again, you weren't speaking as a citizen on a matter of public concern. Yes, absolutely, whether or not the police are lying in an affidavit or having someone lie in an affidavit or using bad warrants, absolutely, that is a matter of public concern. But you weren't speaking as a citizen as part of this debate. You were speaking as an employee. This memo was written as part of your job duties as an assistant prosecutor. And so that speech wasn't First Amendment speech, that was employment speech. Basically, the way you think about this here is, if his employer didn't like the memo and they disagreed with him and they thought his legal analysis was bad. And as a result, they didn't give him promotions because they don't trust his legal analysis. Well, that's not retaliating for First Amendment. That's them being an employer and evaluating his ability to do his job well, right? And so legal analysis is a lawyer's job. And so if your employer thinks your legal analysis is poor, that's not a judgment on your First Amendment protections. That's a judgment on you doing your job. And so as a result, they say, sorry, no First Amendment protection at all here. You weren't speaking as a citizen. You were speaking as an employee. And this case in particular, I think we can really see how it applies in the school setting, right? So the next case is not a Supreme Court case. It's a case called Evans Marshall versus Tip City Board of Education. It's a case from the Sixth Circuit Court of Appeals. So as Rebecca mentioned, I'm a former teacher, so I'm going to go a little civics teacher on you here. The way our federal judiciary works is that we are constitutionally, we have the Supreme Court, right? And then we also have, every state has their district courts. So the district court is the trial court, and every state has at least one or multiple, depending on the state, district courts. That's where the trials happen. That's where the initial cases are decided. And then there's an intermediary appeals court, right? So and that's called the circuit court. And those appeals courts are broke down into circuits, and they're states that are grouped together that are within a circuit. So the Sixth Circuit, for example, contains Michigan, Ohio, Kentucky, and Tennessee. So those four states are part of the Sixth Circuit. And a decision from the Sixth Circuit Court of Appeals is binding within that circuit only. Supreme Court's binding over everyone. Circuit decision is binding within that circuit. So Michigan, even though this case here isn't from Michigan, it's from Ohio, a decision of the Sixth Circuit Court of Appeals is binding in the state of Michigan. Okay. So Tip City, Evans Marshall versus Tip City happens in Ohio, Sixth Circuit decision. In this case, high school English teacher uses some controversial methods in teaching her English class. Okay. This leads to some confrontations between her and her principal in particular, and her and the Board of Education. Oftentimes, I think the dispute between her and her principal were also based upon the fact that the board was annoyed with her because of some of these things and what they're hearing. And the principal's trying to protect himself as well. So in terms of the controversial methods, some examples that it talks about in the case. And this first example goes to show you that there is nothing new under the sun. This case is from 2008, I think it is, 2007. In this situation, we're dealing with the banning of books. Hey, surprise, surprise. So we're dealing with banning of books. There's some talk in the district about books and book banning and the like. Evans Marshall, the teacher, decides she's going to capitalize on this. In her English class, she gives her students a list of the 100 most banned books in schools, has them pick a book, read that book, and write a report on that book. So 2 students are doing reports on the book Heather Has Two Mommies. Their parents see them reading this book at home. In both cases, they're like, what's this book? Why are you reading that? Well, it's part of a homework assignment. What's the assignment? And then they go to the board. They complain at a board meeting about this, and this comes back, to her principal and to her. Another situation, she's teaching a creative writing course, and she had some writing samples that she would give to students if they asked for them on creative writing. One of these samples was a first-person account of this teenager who was vandalizing and desecrating a church. So Miss Evans Marshall has this writing sample. She's running low on them. She sends a copy to the office to have more copies made. The secretary who's copying it starts reading it and is like, oh my God, I can't believe this. Tells the principal. The principal, is unhappy with her. Arguments ensue. After about 2 years of teaching, Evans Marshall is non-renewed. She sues and she claims that her discharge was in retaliation for her, quote, curricular and pedagogical choices, and that this should be protected by the First Amendment, including her right to select books and methods of instruction for use in the classroom without interference from public officials. And so what the court says here, I think, is really important. And they say, in the light cast by Garcetti, it is clear that the First Amendment does not generally insulate Evans Marshall from employer discipline, even discipline prompted by her curricular and pedagogical choices. When a teacher teaches, the school system does not regulate that speech as much as it hires that speech. Expression is a teacher's stock in trade, the commodity she sells to her employer in exchange for a salary. And if it's the school board that hires that speech, it can surely regulate the content of what is or is not expressed. What is expressed, in other words, on its behalf. Only the school board has ultimate responsibility for what goes on in the classroom, legitimately giving it a say over what teachers may or may not teach in the classroom. So, in other words, if I'm a teacher and I'm in front of a classroom and I'm working for Rebecca and I'm in Northville High School, and I'm teaching, I'm not like, my classroom isn't just like Mr. Schindler's First Amendment zone. It's not just my classroom. I'm there on behalf of Northville Schools. And this is a Northville Schools classroom. So my speech is Northville Schools speech, not my speech, because I'm an employee. And so just like when Sabalos is writing that memo, when a teacher is in that classroom and they're teaching, that speech is employment speech, that they're not speaking as a citizen and they're not speaking on a matter of public concern. Even if they are talking about a matter of public concern, they're not talking as a citizen at that point. They're talking as an employee. So what they say in the classroom, what books they select to use in their classroom, even their methods of teaching can be dictated by their employer, and that's not a violation of the First Amendment. So again, if I'm a teacher and I start popping off about politics and getting into subjects that are off topic, and my employer says, no, you need to stop that, and then I don't stop it and I get fired for it, that isn't a violation of my First Amendment rights, because that speech is their speech to regulate. Similarly, pedagogical choices. If our school district is focusing on some teaching methodology, right? This year we're going to be working on project-based learning or standards-based learning, right? Or let's stick with project-based learning, and we're going to have in speakers before school during our continuing ed time. We're going to work on project-based. We're going to want to see you over the course of this year integrate some of that project-based learning into your classroom. And then at the end of the year, we're going to evaluate you in part based on whether you're integrating that stuff into your classroom. And you're a teacher and you're old school and you're like, listen, thanks, I appreciate this continuing ed. This topic sounds really interesting, but I lecture. That's what I do. I'm not going to do this stuff. I've been doing this for 30 years. It works for me. I'm going to keep doing it this way. And then you're negatively evaluated because you didn't integrate this into your classroom. You can't sue and claim that's a First Amendment violation. No, this is our speech. This is our choices. And you as our employee have to follow along if we say so. So that's not a First Amendment issue. And so I think it's a really important concept to understand that we know this. In terms of exceptions, and what does this mean in other ways? One of the bigger calls that I get all the time right now is about, or at least especially maybe a year or so ago, this seemed like it was a really big thing last school year, flags, posters, these sorts of things, right? Schools will call, all right, Bob, what do we do? We have complaints because of rainbow flags, Blue Lives Matter flags, Black Lives Matter posters, posters with religious connotation on the wall, these sorts of things, right? Well, those classroom walls are the school district's walls. So ultimately, the school district can make the determination as to what can and can't go on those walls. Not a free speech zone. So if a school says, yeah, we want to allow our teachers to have rainbow flags or Black Lives Matter flags or this kind of flag or that kind of flag, they can do so. They can also say no. And we've seen this in the last year or so, right? Where we have school districts that are passing policies or resolutions that say no flags other than, American flag, Michigan flag, and maybe some others, but and that's okay as well. Ultimately, that's their choice. The only place where it starts to get a little dicier, I think, is now I'm teaching, and on my desk I have my pictures of my family, and I have personal memorabilia, and maybe there I have a rainbow flag. Okay, well, there's a really good argument there to say that wouldn't be associated as school district speech because that's on my desk along with my personal belongings. Similarly, maybe depending on the situation, teacher has a classroom with an office in the back and they have stuff in their office. That also, I think, runs some differences there in terms of the potential that's more an area where it's clearly sort of their area and it would be considered their speech. Otherwise, though, the classroom walls themselves, that's going to be considered the school district's space. All right. Now, like we see in all sort of politics and issues, things swing one way and they swing a little bit back the other way. Last year, we had a case called Kennedy versus Bremerton, which this is the praying football coach. And now we see a little bit of a pulling back on reins to give employees a little bit more freedom, but it's a little bit limited. So Kennedy versus Bremerton is the case. 2015, school district learns that a high school football coach is engaging in several overtly religious acts with his players. First, he is leading pre-game prayer. So in other words, they're in the locker room, and before the game, coach says, all right, everyone take a knee, bow your heads, and then he says a prayer. So that's one. After the game, he goes and kneels at the 50-yard line along with his coaches and players, and he invites the players and coaches from the other team as well. They all go to the 50-yard line. They kneel. They say they all say sort of a silent prayer. And then afterward, he stands up and gives what the case calls a motivational talk. The motivational talk is essentially a couple of minutes long. It's a motivational talk, but it is focused on sort of Christian concepts, beliefs, integrates Christianity into the motivational speech. He's been doing this apparently since 2008 when he was first hired as a coach. He's I think a JV head coach and maybe a varsity assistant or something along those lines. So he's been doing this since 2008. Upon learning of the activities, the school district instructs him to stop. So the interesting point on the facts was they learned about it because a coach from another team saw the athletic director and was like, hey, by the way, your coach invited me to pray with him after the game. after the last game. I just wanted to let you know how cool that was, I thought. And, that's awesome that you let him do that. And the AD was like, huh? What? He does what? Now, I have a little bit of a hard time believing the fact that the AD never knew that his coach was dealing with a bunch of players and stuff after a game praying, but whatever. That's the situation. They find out about it and they decide to put their foot down. They tell him to stop all of it. He says, okay. He stops the pregame speech. He stops the motivational talk. He says that, he had made a commitment that he was going to continue to thank God for his ability to coach and be with players. And so he would like to continue to pray post-game. He tells that they say no. He says, well, he's going to do it anyway. And he does it. He says, what I'm going to do is I'm going to do it after the game. All the kids go over by the crowd, by the student section, and they sing the fight song. So while they're singing the fight song, I'll go to the 50-yard line, say my prayer, and then be done with it. After the season, he is they tell him, you're free to pray after the game, but you got to do it in your office or someplace private. You can't do it at the 50-yard line because it's this overtly religious act. And you're still coaching, you're still in your gear, so on and so forth. He continues to do it. At the end of the season, they choose to not renew his contract for the following year based upon his not listening to them and continuing to do this despite their direction not to. He sues, claiming this is a violation of the First Amendment right. And this time it goes to the Supreme Court, and the Supreme Court holds on behalf of the employee. Now, I have to admit, if I was the lawyer for Bremerton School District at this time, I would have probably told them to do the exact same thing that they did. Because to me, this was religious speech, even if it was a silent prayer. The act of kneeling and doing this at the 50 is an overtly religious act. And we have other cases about prayer at high school football games and other things. And so I would have said, yeah, that's overtly religious speech at a high school football game with its captive audience. And I would tell him, no, this could violate the Establishment Clause. That's what they did as well. That's what their lawyers told them as well. It goes all up to the Supreme Court, and the Supreme Court says, look, when we look at the Pickering balancing test, we're going to look at that, but we also have to acknowledge that religious speech has sort of a dual protection, right? There's your normal First Amendment protection, and then on top of that, there's also the free expression clause in the First Amendment, that we all have the right to freely express our religion. And so here, the court says we have to overcome this double protection. And given the facts, the court says, no, this doesn't violate the Establishment Clause to allow him to do this, and firing him because of it or disciplining him because of it would amount to a violation of his First Amendment rights. And what they look at when it comes to the Establishment Clause issue is something called the coercion test. They overrule some other tests that were used, and they say, if we're going to say that something violates the Establishment Clause, and again, to go back a little bit, the Establishment Clause is the clause of the First Amendment that says that the U.S. shall not establish a religion, okay? So normally we've said this is the idea that the government has to stay neutral when it comes to religion. They can't be for it, and they can't be against it. They say here, allowing him to do this is not a violation of the Establishment Clause, because to figure out the Establishment Clause, we want to focus on the coercion test, which is this test that says, is the government coercing other people to be involved in or to sit through or be required to be a part of religious ceremony? And they said the facts here don't amount to coercion. And they focus in this situation on the fact that the testimony in the case was, all right, again, this is now when these kids are saying singing the fight song. So people aren't focused on him, they're focused on the kids. During this time when the fight song is being sung, Kennedy puts forth evidence. Other coaches are allowed to do sort of non-coaching duties. Some go and meet up with their family, in the bleachers or outside, on the fence and chat with them. Some are texting friends or family. Some are calling and making dinner arrangements or ordering food or that sort of a thing. And so basically what Kennedy says is that time was kind of like a break time at work, right? So yes, he's on the field, and yes, he's wearing his coaching garb, but this isn't a time where he was actively engaged in employment acts. And so as a result, he had the freedom to do what he wanted. And in this case, he said a prayer, and the court agrees with that. And they said, basically, if we don't allow Kennedy to do this, then that would be the same as saying that a teacher that bows their head and says a prayer, a silent prayer before they eat their meal in the cafeteria also is violating the endorsement clause. Or a teacher that wears a hijab to school or a necklace with a cross would also be violating the establishment clause. And they say, we believe that's going too far, that people have their rights for religious expression, and we're going to protect that in that sense. They focus on this idea of history and tradition, although they don't. They say the history and tradition of our country is one to protect religious individual speech, though they don't really give us a way to analyze that, unfortunately. But understand that this case applies specifically to religious expression. So it doesn't limit, us when it comes to these First Amendment issues in terms of other speech, political speech, or the like. This is specifically about religious expression. All right, so what does this mean? How does this impact when the speech goes off campus, right? Now, again, there's the two components, just like when you're on campus, although it's a little harder to tell in this case. Is the individual speaking as a citizen, and are they speaking as a matter of public concern? Again, if yes, that speech is generally protected unless the balancing test weighs in favor of the school district. If no, the speech may result in discipline, but there has to be a nexus somehow. So I think a really good case on this one is a case called Monroe versus Central Bucks School District. This case, again, high school English teacher. It's always the English teachers. No offense if any English teachers are in the room, but they're passionate. They like to write. They like to express. So high school English teacher, she has a personal blog. The blog doesn't name the school. It's not associated with the school. It doesn't even use her full name under the blog. She just refers to herself as Natalie M. So it's not exactly like she's hiding things, but she's not advertising who it is either, right? The story she tells is, she grew up somewhere in the Midwest, Kansas, Missouri, something like that, I believe. She's teaching out east, Pennsylvania, I think. And this was a way for her to sort of identify and talk back to her family back home. And so she, she has this blog where she talks about her life, about whatever the case may be. She also does talk about education, in some cases in big picture, in some cases smaller. But again, never quite directly associated with the school district. And from what we can tell, for the most part, all of her blog entries were done after school hours, not as an employee. She has a couple, though, that are negative about school administrators, and in particular about her students. She has one blog post that comes to mind, is one where she says, I'm a teacher, I'm working on report cards. When I got into teaching, I really wanted to use the comments in the report cards constructively. I always felt like when I was a student that the comments were all just sort of the same. And I vowed that I would do things differently and be more constructive. And so then I realized that basically I was confined to the drop-down menu. And she says, so here's all the things that I wish were in the drop-down menu. And then at that point, she kind of goes on to a little bit of a diatribe of listing some different things. Some of them are funny, some are cute, some are very mean-spirited and sarcastic. Things like the one that comes to mind is, congratulations, your daughter is royalty, ... She's a drama queen. One is something along the lines of, not congratulations. It may not be the best idea to peak in high school, something along those lines. So she has these blog posts, and just like everything else in the world now, somebody finds out about it and posts it to social media, Facebook, right? And then it gets passed around Facebook. They figure out who it is that's writing it based on her content. And next thing you know, principals getting calls complaining about this blog post from the teacher. The local news truck ends up in the bus loop because they want to interview students and other staff members and principal about these blog posts. And so she gets put on suspension because they're going to investigate all of this. While she's on suspension, she ends up going on a planned maternity leave. From that maternity leave, she then, when she comes back, it doesn't say whether she was ever disciplined, but after she gets back, she has some negative evaluations, and eventually she is terminated based upon poor performance. So she sues, asserting that this was a violation of her First Amendment rights, that this blog was outside of school, she wasn't speaking as an employee, and so as a result, this violates her First Amendment rights. And so the court says, okay, she wasn't speaking as an employee at the time. We're going to find reluctantly that she was speaking on a matter of public concern because there were some blog posts that were about ed policy and that sort of a thing. But even if, in this case, the balance weighs in favor of the school district because it had an adverse impact on the school. You had parents taking kids out of her class. They didn't want her to be their teacher anymore. After she came back, you had other kids or parents who were saying, don't put my kid in Miss Monroe's class next year. I don't want her. I don't trust her. And so, there was also all the disruption and everything that happened when it first came out. So the court said, look, ultimately, in this situation, the balancing act weighs in favor of the employer. I think important to note on that is the speech wasn't overtly political. This reluctance to find a matter of public concern is important. She wasn't engaged in serious public debate on this blog. Maybe that would have been looked at differently if that was the case, but it wasn't. And so as a result, the court then says, okay, in this case, the balancing test weighs in favor of the district. All right, so that's staff expression. We're going to get more into social media and social media usage and some tips and do's and don'ts when it comes to social media. Before I do, I don't know if there's any questions on the Q&A. I don't see anything in there right now.
There is one, Bob, if you can go back to the Pickering case.
Yeah.
The Erica asked the question, great question. If this school employee was not a resident within the district, would they still have had the same outcome?
That is a great question. And the answer, I believe, is yes. Because I don't even remember technically if Pickering was in fact a resident of the school district, but it is still a public debate that impacts him. And as an individual who has knowledge of that situation, he's engaging in that public debate. And so even if he's not a resident, he's speaking to the residents who are voting and has understanding relative to the issue at hand. And so, yeah, I think it's a great question. And to me, the answer is no. I don't think it does matter if Pickering was or was not a resident of the school district. I think if they are a resident, then it makes it more likely to get protection because they have an even further vested interest in it. But either way, if they're engaging in that process wherein they're a citizen speaking on a matter of public concern, then protection is there. I would think of it this way in sort of a modern context, right? If a teacher who's not a resident comes to a board meeting and they go to public comment time at the board meeting and they're talking about bond dollars, they're talking about union issues, they're talking about support that's coming to the teachers or not to the school board, right? During that time, they're in sort of a free speech zone. They're talking about this generally. Obviously, it's an employment issue, but they're speaking at it in a public debate context. And that speech is generally going to be protected unless they went off the rails and really started attacking people in a way that would hinder their job. That's going to be protected as well, whether they're a resident or not, because they have an understanding and they're joining in the debate on that issue. So great question, though.
Yeah.
Okay. School controversies on social media. So, boy, social media, it is, I joke that, Facebook, I think either at one time or at all times has probably been the bane of all of our existence, because it is, say here, a conversation with 1 million people and they're all convinced that they know more than you do, right? One of the problems that we talk about societally with social media is that it allows everyone to be an expert. Why? Because they say so, because we all have opinions on every topic. And Twitter or X and Facebook or Threads or you name it allows us all to be publishers and give our thoughts immediately, right? And we can speak about that as an expert, even if we have no expertise, including school questions, right? It's important to know in thinking about social media, when controversies come up in your building or in your district and there's discussion on social media, it's important to understand a few things about social media. And you may know this inherently already, but the reality is that crisis situations are accelerated and enlarged as emotions get attached to them. Social media is a big way for emotional language, discussion to be not only expressed, but perpetuated and grown, right? Emotions are contagious. Anyone who's been in a room where someone's upset knows this, right? You feel it as well. And there are some people who stay calm. Some people are what I call emotional chameleons, right? They get into the emotional setting around them and that builds, right? When it comes to social media and controversial issues, people who thrive in dysfunction or people who like controversy or debate even are the ones who are most likely to sort of catch and spread this and spread negative comments in particular, right? As negative voices and dysfunctional people are amplified, it's also important to understand that people who don't want to engage in this sort of dysfunction, they back away. They're not going to throw sort of themselves into a pack of wolves. And so what happens is we get a situation where the angry voices, the dysfunctional voices, the voices of people who are just upset about what's going on and want to complain about it, they're all amplified, and there's no rational counterpoint because people don't want to then throw themselves into the mix. And as we've probably all seen on social media at one point or another, when one person tries to be rational, oftentimes they're then devoured by the wolves. And so, we need to know that that's a reality, because when social media hits us, when there's an issue going on in our building or our district, and it begins to be engaged in social media, and all we see is the negative, it feels like, oh my gosh, everyone's against us, right? Everyone thinks that we're bad people. We're just trying to help kids. We're just doing this. This isn't really what happened, right? So what happens is, we think that that's the reality when it isn't the reality. It's just those are the voices that get amplified within this forum. So it's important whether you're a building administrator, or some level of a central office administrator. You're especially the building level folks. You're the eyes and ears for the district. You're closer to the kids. You're closer to the parents. You're probably going to see and hear about a lot of this stuff and these conversations maybe before the folks at central office are. So it's important. You're the eyes and ears. Screenshot this stuff when you see it. Alert the superintendent. Alert the assistant superintendent. So that they know that this stuff is going on, so that they can address it or work with you to address it and address it in the appropriate manner. Do not get sucked into sort of online conflict spiraling, right? Sometimes the best response is no response, or maybe a more measured response. Don't get into arguments online. Offer instead, if there are people out there that you think you can talk to, try and take that offline and have personal conversations with those individuals. That's going to be far more effective than trying to engage on social media. If you do respond on social media, make sure that's always a very personal thing and not just sort of a copy and paste answer. But more often than not, it's better to control the venue and control how we communicate when it comes to sort of these types of issues, right? If we're in there trying to have a complex discussion on social media, it doesn't work. People aren't going to read it. People are going to write you off. They're going to come up with reasons why whatever you say on there is wrong, and they're going to try and lob those at you, right? So don't engage with it. If you engage in a personal conversation, whether that's on the phone, whether that's in person, even through email, although it's better to have voice and or face or both, because then you can get context, you can get understanding better. That's a much better way to sort of communicate with people who are all fired up on this stuff, because you have a much better chance of getting them to see things rationally. Again, it's better to address these things in a controlled form if we're having these controversies going on, instead of engaging in social media. Send out a district-wide email or a building-wide email or a letter, something where you can craft the narrative, where you can get your message out, and it's not going to be an avenue for debate, right? Don't do it and put it on the district's Facebook page. Send it directly out as an email or something along those lines. That's a much better way to deal with these issues from a functionality standpoint. Now, when it comes to social media usage, we as Rebecca, as she used with all of her berries, I've been doing this school law thing for a while now. I've been doing it from the time before social media was really a big thing. I think probably I remember being in law school when this new Facebook thing came out. And it was then only college students who could even have accounts. Probably the first thing that I saw when I was teaching was MySpace. And back in the olden days when social media first came out, the general response from school administrators was no. In ed school, they taught people don't have social media. If you had Facebook as an undergrad, get rid of it. Don't have any social media. Don't engage at all. But that ship has sailed, right? It is not reality anymore. So instead, it's really important that both we as administrators think about, and we advise our staff members to think about how they're using social media, okay? And it doesn't have to be all bad. It can be used well. Ultimately, this is how our society, we speak nowadays. So we have to think about how. So in terms of keys, right? One is to be thoughtful and restrained always on social media as much as possible. Teach your staff members, if they've had a few drinks, put Twitter away or Facebook or Instagram or whatever the case may be, right? have social media, but use it wisely. Recognize that free speech isn't unlimited, okay? Just as we saw with Natalie M., with Ms. Monroe, what you say outside of school online can come back and be used against you from an employment context. Free speech isn't always free. That's just how it works, especially if we're looking at, even if we're talking about matters of a public concern, right, which is what we saw with Ms. Monroe. Social media pages that are created to look like district pages may very well be treated like district pages and district speech, not individual speech, even if they aren't an official part of your job, right? So in some cases, a teacher may have a social media page of some kind or another that they use for their classroom, right? Something where you have, I think I'm thinking in the university context, and like Moodle or other of these formats where you have, message boards or social media type functions that they may have for their class for students to be able to put in assignments, but also to have chats, engage in discussion, these sorts of things. And that's obviously part of their duties. And that speech would not be First Amendment speech. Similarly, I've seen other issues. One issue in particular that comes to mind was a teacher and coach who was a high school teacher and baseball coach who had a Twitter page. This Twitter page was not something that the school assigned him to do. It wasn't part of his duties necessarily, but the Twitter page was set up in a way that looked like it was a district page, right? His Twitter handle was at Coach so-and-so. When you looked at his bio there on Twitter, it said it was all associated with his work. It was whatever, a such and such university graduate, social studies teacher at such and such high school, junior varsity baseball coach at such and such high school, and then had a link to the baseball team's webpage. In his picture, he had on his baseball uniform as a coach. The background picture was a picture of the baseball, the district's baseball diamond with the logo on it. So when the average person looks at this page, this is not a page of just this guy. This is a page of this teacher and coach. And a lot of his Twitter stuff was about baseball program or this or that. But one day he gets frustrated about politics and he starts popping off. He gets in discussions with kids, says some insulting things about the other side politically. And next thing you know, the school's getting emails. How can you let your teacher be doing this on their Twitter page, so on and so forth? And eventually the school takes action. And in this case, the teacher was probationary. They end up dismissing the teacher because of this sort of this poor judgment in terms of how they're using their social media account. And ultimately, if this page had no association with with the school, I think it would have been different. But here, because it was clearly associated with the school, this makes it look a lot more like employee speech and changes sort of that analysis. So when it comes to staff, recommendations that I like to give are things like, do not friend students unless it is a professional social media page. So if you have a personal social media page, don't follow, don't friend, whatever the terminology is used on a given social media page, your students until after they're graduating. Right? Once they're graduated, fine. You want to become friends with them, be friends with them. While they're teaching, you have to keep while they're your students, you have to keep a professional distance. It's different, obviously, if it's if it's a professional context and you're using this for professional reasons, then obviously that's different. If you're texting students and giving them your cell phone number, we have to be extraordinarily careful that this is always done professionally. I recommend not giving kids your personal cell phone. Now, I know that this happens all the time. Heck, I have 2 kids in high school right now, both play multiple sports and both have, personal addresses or personal phone numbers for their coaches because their coach will text things out to the team. But I also know I have other coaches who use things like Remind instead and send out messages that way. And they'll have a Remind for the parents and for the students and one for just the students. I think that's a way better way to go than giving a personal cell phone number to kids, because it eliminates a lot of those things. So I would recommend, if possible, thinking about researching if your coaches and your teachers aren't doing this now. And this isn't an ad for Remind. I'm sure there are plenty of other apps out there that do this. That's just the one that I see in my life. Do something like that instead of phone numbers, because I can't tell you as a school lawyer how many times I've had to deal with scenarios, fire staff members, fire coaches because of text messages, because of this last point, right? If you hear about staff members who are being what I like to call overly familiar with students, meaning maybe it isn't way over the line and we're not talking about something clearly inappropriate, right? Sexual messages, pictures, that sort of thing with students. Even if we remove that, what we see is coaches, teachers texting with kids like they're their buddy. And that's inappropriate. One, because there needs to be this professional distance between the two, but also every situation where I have seen the clearly inappropriate stuff happen, it starts like that and then leads to that direction. So if we can cut off when we're at the overly familiar part before we get to the really inappropriate stuff, let's do it. So if you hear about teachers, coaches, staff members engaging in text messages with students that are, again, what I call overly familiar, sort of texting in ways that are, telling crude jokes, using foul language, that sort of stuff, let's try and cut that off as soon as we can. Address it right away. Okay. Any questions or thoughts on the issues of social media, text messages, and things before we get to investigations? No? Okay. All right. So something comes up, right? You hear about this text message or some other issue, and you need to do an investigation. I want to talk about some tips, some do's and don'ts when it comes to those investigations. Importantly, when we use the word investigate, I think we often think of, Sherlock Holmes or some serious thing. When I use the word investigate, all I mean is we're doing some fact finding to figure out what's going on. In other words, it's not a situation somebody comes to us, tells us what happened, and then we jump right to the result, right? We're not jumping right to the result. We have to do some level of investigation. Maybe the investigation is speaking to the one other person involved. Maybe it's speaking to 30 people and doing sit-down interviews and having written statements. Both of those things are an investigation, as I use the word, and depending on the issue, one might be right and the other might be wrong, or one might be wrong and the other might be right. So it's important to think about that and understand that framework. So why are we investigating? Well, we're investigating to engage in informed decision-making, right? Somebody tells us something, we're like, oh, that's horrible. We can't just react, right? We have to engage in informed decision-making so we know what's going on. We also want to make sure that we're adhering to district due process requirements or constitutional due process requirements, and maybe what we have in our handbooks or policies. We also that way create a record of what happened, right? Here's what happened and here was our response, and that investigation does that. All of this will avoid bad publicity, potential liability, lawsuits. It will allow you to create documentation that may be needed for a grievance, for a lawsuit, for an OCR complaint, an EEOC complaint, etc. Okay. And of course, it'll allow you to be your attorney's best friend, because then when I come into the situation, it's much easier to be involved, or whoever your attorney is. All right. So what are the basic rules of an investigation? One, act quickly, but you don't have to be hasty about things, right? You don't have to get extreme. And this is my answer with all of this. As much as we can, we need to have a level head. We need to be the adults in the room. We want to act quickly, but don't be hasty, right? You get a complaint about something important, something that you believe could lead to discipline. This isn't something to put in the inbox and wait until we have time for it. We want to make time for it. We want to prioritize this, but we don't have to be hasty, right? Be comprehensive, but not crazy. What do I mean by that? What do I mean is a fight happens on the playground during second lunch, right? Well, we don't have to interview everybody from second lunch to see what they said. No, someone comes to us, they tell us about the fight. We ask them about who was involved, what happened, who they knew. We interview those people. During the course of our interview, we ask people, is there anyone else I should be talking to? Who else do you think saw this? Then interview those people, right? We don't have to interview everyone, because at a certain point now we're just sort of spreading rumor, or we're stirring things up. People are like, I had no idea a fight even occurred. I was here or there. Ensure the retention of evidence, right? Nowadays, most of our evidence comes from these things. So if you see something, screenshot it, find out how to preserve it, so that way it doesn't get erased and we don't lose it. Think about video surveillance always. If something happens and it's in an area where we have security cameras, pull the footage, pull it right away, or review the footage, and then pull that evidence, right? Because your surveillance systems are going to erase, depending on what it is. If it's a bus or a hallway, it might be different. Maybe it's 10 days, maybe it's 15 days, maybe it's 30 days at most, probably. But after that, that's going to be erased. And so make sure that we're pulling that and saving it somewhere if we need to. Think about not only situations where this video surveillance about this issue, but could there be other surveillance we want to look at? I just dealt with an arbitration a couple of weeks ago where we had a scenario where a paraprofessional was accused of engaging in some inappropriate physical contact with students. So when I say inappropriate, I'm not talking about anything sexual or anything. This was a preschool para who would do things like pick a kid up by the arm or pull them back by the hood. These sort of things that were overly physical that we would do not want to have, would not want to encourage, right? Someone came to the district with a complaint about what she saw in a classroom with this para. Para denies it completely. It was in the classroom, so there was no video surveillance, but the folks in HR and the principal thought enough, but the principal was the one who thought about it, was like, I'm going to go back and look at surveillance video footage that I can see to see if I see her doing this any other time. Sure enough, they saw it in the hallway, they saw it on the playground, her doing the same thing with kids. And so now her denial, where we didn't have the footage, was less convincing than it otherwise would have been, because now we had this video surveillance footage. So think about those things as well and how you can do that. And then again, pull that video. Obtain written statements. I think written statements are really important. We think about it oftentimes with kids, but let's do it with adults as well. If we have a serious investigation or an issue that we're dealing with, because stories change, memories fade, right? And so it's important, and this goes back to the whole like acting quickly. One of the reasons why we want to act quickly is because memories do fade, or things things get out, people start talking, and all of a sudden our memories begin to conform to what we're hearing, or maybe they do a little bit. If you've ever looked into the psychology of investigations, our memories and our minds are crazy things in terms of what we can convince ourselves of how things happened, or how we can even change memories in our own head. So it's important to get to these things early, create those written statements to be able to hold people to what they said and did. Be guided by something. When you're doing an investigation, don't just use your gut, right? Use district policy, use your employee handbook, definitions that might be in there when you're investigating whether something is wrongdoing, because ultimately that's important because it gives us some guidance to think through and analyze the process. Always provide due process as required. So what is due process? Due process, generally speaking, is notice of what someone is being charged with or what they're being accused of, and an opportunity to give their side of the story. It's always important, if we're ever going to give discipline to somebody, whether that's student or staff, that we provide due process. And that, again, doesn't always, maybe under policy or under contract, they have a right to a hearing or something more formal. But even if not, it's always important that if we're going to discipline someone based on some facts, we've talked to them about it. Even if, let's just say, we do an investigation, we find out some facts, we interview the person who is supposed to be the wrongdoer, they give their side of the story, and then afterward we find out more facts. We can't just incorporate those facts into our discipline and use them without then bringing the person back for another interview or talking to them again and saying, okay, I learned some more things. What do you say about this? Right? If we're going to use that in a discipline, that person has to be made aware of it in advance and have an opportunity to give their side of the story. Suspension pending the results of the investigation is okay, especially with employees. That suspension is going to be with pay, because then it's not disciplinary, right? It's just a matter of protecting the investigation, and that's okay to do. If we're talking about students, we can still do that, although the caveat being, be very careful if we're talking about a student who is certified special education, because we have that 10-day cumulative requirement that we have to deal with. And if that student is out more than 10 days, that can be considered a change in placement. And then we're in some danger of violating the law. Not some danger, we are violating the law at that point, right? And then, especially if we're talking about employee issues, it's always important to talk to your supervisor, talk to HR about what's going on. They're going to have a better understanding potentially of certain things. And so it's really important that we do that. We know that we understand. It may eventually be that you're going to do the investigation anyway, instead of HR doing it, but HR can be there to guide you. They can maybe know some things that you don't, give you some tips, pointers, etc. Pardon me, I'm going to pull my shade down a little bit. A good example of something that like this and the importance of reaching out to those in HR or others was years ago. I had a school district client of mine where a high school principal finds out that one of his high school teachers said some very inappropriate things in the classroom. He finds out about it, meets with the teacher, says, basically, did you say this? And the teacher was like, well, yeah. Principal says, you can't do that. That's inappropriate. I need you to go and apologize to your students and don't ever say that again, right? So they have that meeting, and the principal wasn't necessarily thinking about doing any other discipline at that point, but hadn't necessarily ruled it out, but was talking to the superintendent a couple of days later and said, hey, by the way, Mr. So-and-so, we had this issue with Mr. So-and-so, he said these inappropriate things in class. Superintendent's like, what? What superintendent knew and principal didn't was that this employee had been disciplined multiple times for saying inappropriate things, including the year earlier at a district function where he was disciplined. And actually, we had just gotten an arbitration result back that we had won 5 months before this happened. And so, now the superintendent's looking at it, who also handles the HR functions in the district. He's looking at it and going, no. We end up moving for termination in that situation because there was this history, and then there was the inappropriate statement here. So it's important to engage with people in HR or your superintendent, whoever it might be, to help understand these issues when they come up. It's also important to understand, again, I remember I said before about going to your policies or going to your handbook. Definitions are important, right? In society, we oftentimes throw around words. We throw around legal words that have weight. These are heavy words. And sometimes we're using them about how we feel, and they aren't necessarily being used in the same context as their definitions. And so it's important to understand definitions, right? So like, for example, discrimination. What is discrimination? Discrimination is being treated differently, especially it's a failure to treat persons equally when no reasonable distinction can be found between those who are favored and those who are not. Legally speaking, discrimination is always based on a protected classification, meaning my race, my religion, my sex, my sexual orientation, my creed or ethnic background, right? These are protected classifications. And if somebody is discriminated against, treated differently or unfairly, generally when we talk about discrimination, we're talking about in a tangible job action of some kind. Because of those things, that's discrimination. Harassment, again, is a word that we throw around a lot, right? But what does it mean? It is words, conduct, or action repeated or persistent that are or extreme, that are being directed at a specific person for the purpose of to annoy, alarm, or cause substantial emotional distress in that person. In the legal context, again, harassment always means that it's based on a protected classification of some kind. So I'm harassing you, I'm treating you different, I'm treating you poorly because of your sex, because of your race, because of your religion, your sexual orientation, etc. Right? It has to be persistent and repeated or severe. It is important if somebody raises this issue of harassment that you check your board policy, because I have read some policies before that look at the word harassment very broadly and don't necessarily tie it. They'll talk about harassment and then unlawful harassment. Unlawful harassment will be harassment based upon protected classification, but harassment could be more general. I think it's very important that you know that if your policy talks about that. When we talk about harassment, there are two types. There's quid pro quo. Quid pro quo is a Latin phrase that means this for that. Quid pro quo harassment is what I like to call Mad Men harassment. If you've ever watched the show Mad Men, right? This is the if you want a promotion, let's go out for drinks Friday night, right? You say no, you don't get that promotion, right? So that's sort of quid pro quo harassment. This was really sort of the harassment I think that we thought about when harassment first came into context. It's very, I think most people have gotten smart enough now. We don't see quid pro quo harassment very often in society anymore. Instead, what we see most cases now are relative to hostile work environment harassment. And so again, here's a phrase gets thrown around a lot. I'm being subjected to a hostile work environment. Well, what does that mean? That means more than just simply, my boss every day is like, Bob, you got to come to work on time. You're 15 minutes late again. And every day they keep telling me this, right? They're not harassing me. They're asking me to do my job, right? Harassment is, again, based on that protected classification. You're being put in a situation where the average reasonable person wouldn't do that job because of the impact of that activity. It's sort of a subset of discrimination. So again, it has to be based on a protected classification. Bullying is defined specifically under Michigan law. And it's important to know that Michigan law, bullying is only about kids, right? Adults can't violate Michigan law by bullying other adults. Okay, it is a protection for students, for children. That having been said, I think the definition is important because it's something that we might hear this even amongst employees. I'm being bullied by so and so. Okay, well, what does that mean? Well, look at the definition. Understand what the definition is. I like to think of bullying as harassment without the protected classification. It is one person acting cruel to another for the purpose of being cruel. But much like harassment, it has to be over time, it has to be substantial or repeated, and has to then have an objective impact on the student. So one time of me being a jerk, if I'm a kid, I'm a jerk to somebody else, I'm not being a bully necessarily, right? I'm just, kids are often mean. If that's the case, probably all kids are bullies. I know because I have 4 kids in my house. The reality is it's about the repeated actions for the purpose of trying to annoy, frustrate, cause emotional distress. So it's important we know those words. And then when somebody comes to us with an issue, it's important for us to follow up and do our job to ask questions, because oftentimes a harassment complaint isn't as clear as you would think it would, right? Most people, or a lot of people, may throw these words out to try and get action, but a lot of times, especially if somebody is being harassed, they might feel embarrassed about it. They might be sort of trepidatious to speak. They don't want to get themselves in trouble or somebody else, right? They don't want to be the center of attention. They already feel the center of attention. So the way they come to you might be a little bit different, right? They might not come and say, I was sexually harassed by so-and-so. They might just say, so-and-so has been bugging me or has been on my case, or, I'm really getting tired of so-and-so. And maybe then we as a supervisor have to ask some questions and try and figure out what they're talking about. We can't just be like, well, look, they're a jerk sometimes. Just got to blow them off. Like, let's ask some questions and figure out, sort of what we have, right? Is what we're talking about just sort of a gripe or a conflict between two people that we need to deal with? Or is it something more? We need to consider those facts. We need to compare that then to those definitions and have an understanding, right? I think it's important to know, we have this sort of he said, she said myth in our society. Well, we can't do anything about it because it's he said, she said, right? It is what it is. Well, no. The reality is, whenever we're doing an investigation, we're likely going to have to make credibility decisions. And that can be done even if there's only 2 people involved in a situation. You're going to have to interview those people, have those conversations. Maybe the story doesn't check out. Maybe one person's story keeps changing during the course of a conversation with them. And so then we all of a sudden we realize, okay, I'm not sure this person's story is lining up. It doesn't make sense anymore. So now the one person's going to seem more credible than the other. That's okay. That's a natural part of investigations. It's hard sometimes to make that conclusory statement and say, these 2 people are saying conflicting things, but I believe this person and I don't believe that one. But that's part of our role in an investigation oftentimes, right? When you're doing that, when you're trying to make those credibility decisions, try your best to remove bias. Now, that doesn't mean you have to ignore history. if somebody has a history of lying to you. You can know that and understand that. But as much as we can, we want to remove the bias in meaning our personal feelings about these individuals and look at the situation, right? I find this is most hard, not even when we feel less than kind about someone. I feel like it's harder for us a lot of times to remove bias when we like someone. And so we have to know that and say, okay, my instinct is I like this person. I've worked with them for years. I've always believed them to be a good person. So I have a really hard time believing that they could have done this. In that scenario, we have to try and go, okay, everybody is different. We don't know what they're going through. We don't know what's inside of their heads. We need to remove that and just do the investigation. If you don't think you can remove that bias, then have somebody else do the investigation. It's okay to admit that. I don't know that I can be objective in this scenario because I've been friends with this person for 25 years, right? That's okay. Have the assistant principal, and if you're the principal, do the investigation, or call up to HR and say, hey, look, I don't think I can remove my own personal bias on this thing, right? And address that. During, I was thinking about this last bullet about COVID, right? During COVID, we were all at home. We were all watching too much TV. We were all on social media too much. And in addition to COVID, we had, Me Too going on. There was the big Me Too movement, or the push in the Me Too movement. And, we had George Floyd, all these racial issues so we had all this stuff coming together, right? And one of the debates that I always saw online and on TV at that time was you had one side who were saying we have to believe victims, and then the other side was screaming and going, "What? No, people lie. We have to have due process. We don't have to believe victims." And I'm sitting there as a lawyer going, guys, stop. You're actually both right. We need to think about how we look at this, right? So when I think about this issue, what I say is we need to believe allegations. We need to believe victims. Yes, that is true. But we need to believe them to the extent that we have to do the investigation and provide due process, right? Meaning, somebody comes to me and says, hey, George sexually harassed me. He said this and he did that. Our response can't be, I know George is a good guy. Sometimes he just jokes a bit too much. He was just joking, right? That is, we're not believing victims. We're not believing allegations. When you blow those off and you don't consider them a reality, or you investigate with your biases and you don't give a real investigation, right? Instead, we believe it to the extent that we have to investigate and provide due process. And again, we do have to provide due process, absolutely, for everyone. We're not going to discipline them. We're not going to make decisions without giving them an opportunity to tell their side of the story. So now, specific things about staff, it's important to understand when we're investigating staff. Okay, when do we investigate? Well, in particular, if you have information that, if true, could lead to discipline or could cause a disruption to the educational environment, you have to investigate of some kind or another, right? Especially if it could lead to discipline. Again, when we're talking about staff, the basic rules apply that we talked about before. Sensitivity in particular, we have to think about because we're talking about somebody's job, their work reputation possibly. So, it's important that we try and keep conversations about this private. And when we're doing investigations and we're having conversations, it's important to tell those people, hey, look, I need you to keep this private. This conversation in this investigation is between us, and what we talk about, what you tell me, or when we talk about, needs to stay here. You can't talk about this with others, right? That having been said, it's important that we know that we when we're interviewing someone, we can't guarantee confidentiality to them because we're in the process of an investigation. So we're going to have to talk to more people about what's going on. We have to make sure we tell them, hey, look, I'm going to do everything I can to keep this private, but I can't guarantee confidentiality on this one. We also think about union involvement, right, and representation. If we're interviewing someone, especially if they're the person who is accused and they want a union rep, we have to provide one for them. And we'll get more into what that means. But we want to think about that as well. If the individual says, I don't want a union rep, I don't want the union there, that's okay. I would, however, document that to make sure it's clear. Either that's through an email or something that says, okay, you don't want a union rep, we will not provide one for you, that sort of a thing, right? Or at least a document that you offered it. Involvement of HR, again, keep them in the loop, at least minimally. Documentation is really important in this process, and we'll talk a little bit more about documentation. But one point is, don't wait until it's too late. Your memory is fresh at a certain point. The longer you wait, the more your memory is going to get fuzzy and the more things you're going to forget because other things happen. When we're interviewing the victim in a situation, right, somebody who has been wronged or has been the center of a bad act of some kind or other, whether that's harassment, whether it's a fight, whatever the case may be, right? I always like to interview the victim, or maybe it's better said, the complainant first. You know, somebody who comes to us and complains about an issue. I want to interview them first because I want to know the full scope of what they're saying the problem is, right? Ask open-ended questions when you're doing that, meaning don't just confirm to them what happened and have them say yes or no. Let them tell the story as much as you can, but let them tell the story. Be sure to get names and details. They may not want to give you names. It's important that we tell them, hey, look, if I'm going to investigate this issue, and by the way, I have to investigate this issue, I need to know who to talk to. So get names, get details. Don't, again, you know, this could be hard. Assure them it's necessary. Don't promise anonymity, because when they about the names, they're going to want to say, well, I don't want them to know that I told you this. And what we have to say is, hey, look, what I say when I do an investigation interview is I can't guarantee confidentiality. What I can tell you is this: I'm going to keep what you tell me as confidential as I can. And what that means is I'm going to talk to other people about facts. And I'm going to hear their side of the story about those facts. I'm never going to say, well, listen, you're telling me this, but Sue told me that, or Sue told me so-and-so. What do you have to say about it? Instead, what I'll tell them is, well, it's been reported to me, so on and so forth. What do you have to say? Or another witness told me this. Now, if Sue and the person being investigated are the only two people in the room at the time, they're probably going to know who Sue is. That Sue's the one who told me this, right? And this is what I'll tell them. But I'm not gonna put you out there as the individual, but they might be able to figure it out. That's why I can't guarantee anonymity, but I will try and keep things confidential as much as I can. And I think as an interviewer, that's a better way to go. It makes both the person who's being interviewed now and talking to you more comfortable, and even when you're talking to somebody else, if they see that you're not throwing names out there all the time, and that they might not be, they don't want to be one of those names you're throwing out there as well, it's going to make it more likely for them to talk in those situations. Oftentimes we get this one. If you're an administrator for very long, you're going to hear this. Listen, I wanted to let you know about something. But I don't want to file a formal complaint, or I don't want an investigation. I just want to make sure you know about it, right? it's important to understand that, that we have to deal with that, right? And it's okay to tell them, hey, look, I appreciate you not wanting to be involved, but I have to do something about this, right? Now that I've been told about this, if I don't do something, this could lead to liability. This could lead to other problems elsewhere. I'm shirking my responsibilities if I don't do an investigation or if I don't talk to some people about this. Tell them that it's okay. And then go back to hey, look, I'm gonna do what I can to keep you confidential. Inform them of the retaliation policy. Every district will have a retaliation policy of some kind or another, which means even if you tell me something, right, and I investigate it, and you say to me, Bob, I was being sexually harassed, or so-and-so is sexually harassing so-and-so, and you come to me about it, even if I find out ultimately that what happened was not sexual harassment, if that person then begins treating you differently, that's retaliation. And so, that's something that's important, or, could be retaliation. So it's important that, we let them know about that policy and say, hey, look, I'm going to investigate it. If anyone, gives you any trouble because of this, come back and talk to me about it and we'll deal with it. We'll address it. Right. If the person coming to you, again, is the victim in a situation, especially if they're claiming something like harassment or discrimination or something, let them know that you will inform them of your findings, but not necessarily about the action that we're taking in response, right? A lot of times when somebody comes and they're complaining about somebody else, what they want to see is they want to see the scalp when you're done. They want to see the blood, right? They want to know that person had to suffer about it. So what we're going to tell them is, yes, we did find that harassment occurred, or no, we didn't. And here's why, right? Now, what we're not going to tell you is we're going to fire that person. We're suspending them for 5 days. They have to go to a class, so on and so forth. Instead, what we're going to tell them is, yes, we found harassment occurred. We are addressing this. Maybe you're going to tell them to the extent that, hey, we're separating you two. If this person makes contact with you, let me know, so on and so forth. The rest of it, if they ask details, you tell them that's a personnel matter. It's between them and us. But understand, we're taking it seriously. We're dealing with it. If you have any other concerns, be sure to let me know. If there's any other problem, be sure to let me know, because we are addressing this and we're making sure that it doesn't happen again, right? That's how we address that, instead of talking about the specifics about what happened. Witness statements, again, it's really important, especially in discipline situations, because you may need those later on. As I said, the sooner the better. Always interview individuals separately. Group interviews, I think, are a bad idea, because either basically the most vocal, the most outspoken, the most gregarious person in the group is going to become the spokesperson for that group oftentimes. Or another problem you'll have is that stories begin to conform to each other. One person tells a story and goes, oh, yeah, that's maybe oh, yeah, okay. So instead, if we talk individually to people, we'll get different aspects of the story oftentimes. And then if they're all the same, it makes it much more credible and believable, because we interview these individuals separately and their stories all lined up. And then it's like, okay, now that lends credibility to my investigation. Be sure to focus on fact and not opinion, right? And when I say opinion, I'm also going to include sort of conclusory statements in there, meaning Joe was acting inappropriate all day today. Okay, well, what does inappropriate mean, right? Because what's inappropriate to you might be very different than what's inappropriate to me versus someone else, right? So when you say Joe was being inappropriate, what does that mean? Oh, he was saying just, stuff you shouldn't say in school. Well, again, what does that mean? Give me the words. Give me the context in particular, right? What was said? How did he say it? What was his vocal tone when he said it? Was he, again, he was angry. How do you know he was angry? Well, his face was red. He was yelling. He was yelling. What was his volume at? A 1 out of 10. Oh, it was a 9 for sure, at least, right? get those details of the facts rather than just the conclusory statements, because that's going to allow you to then do a much better investigation. Because then when you talk to somebody else, you can say, did you see Joe that day? Yeah. Did Joe seem agitated to you? Yeah. Why did he seem agitated? This, or no, he didn't. Well, so it's my understanding that his face got a bit red and his voice got elevated. Did you see that? Yeah, I guess I did. Right. So those facts, getting the specifics of the facts, are really important. This can be very hard when it comes to uncomfortable or difficult conversations, right? If we're talking about a sexual harassment scenario, we might be talking about very uncomfortable and inappropriate words, phrases, actions. And so as a result, that can be really hard. And we don't want to ask those questions because it makes us uncomfortable as well as them. But we have to. That's part of this role. And we have to know that without it, we're not doing our job. And we have to ask those specifics. Okay. With the adults, I prefer, it's easier, I think, sometimes if we write the statement and have them review it and sign it, right? Interview them, take your notes afterward, type it up, give it to them and say, hey, this is the statement I made relative to our interview. Does it look good to you? They read it. No, I don't, talk about what's consistent, what's not. You can make changes if you need to, or add things in there and then have them sign it. That goes a long way. This may allow you to avoid calling them as a witness in some cases, probably not. Most of the time, even in arbitration, a witness statement is just going to be considered hearsay, but it's possible. At the very least, it will be good to help hold them, be something that refreshes their memory if you're going to a hearing. If you're talking about the accused employee, the question often, well, what if they refuse? What if they say they're not going to sit for an interview? Well, they can't. You're the employer. They're the employee. You can tell them, no, we're setting up a meeting and you have to come to this meeting. This is part of your job as an employee. If they don't show up to the meeting or they won't come to work or whatever the case may be, that can be considered an insubordination. Now, we can't force them to talk once they're in that meeting. They can sit there and say, I'm not telling you anything, right? And we can't, as much as we might like to, go and open their mouth and make them talk. But what we can do is we can tell them, hey, look, here's the deal. This is your opportunity to give your side of the story. And I'm going to come to a conclusion on this investigation, whether you tell me your answers or you don't. So right now, this is the information that I have. And if you're not going to tell me anything, I'm going to go based on this, right? So that's where I go if an employee doesn't want to say anything. Sometimes you might have a scenario where you have an employee who's sort of pleading the fifth. Understand, pleading the fifth only matters, doesn't actually necessarily apply to you because you're not the police, but they might want to do it if there's a potential for criminal action out there. There are means that you can go by. There's what's called a Garrity waiver, where you can basically say, hey, look, this interview is for employment context only, and this waiver says that you are limiting this to the employment context, and that I am not allowed to testify about what was said here in a criminal context, or what we gather here, that this is for employment purposes only. Depending on the scenario, they still may or may not be willing to sign that and give testimony or give statements about it. But again, that's fine. Even if there's a criminal proceeding going on, what we're doing is not criminal, right? So a lot of times we'll say, well, we can't do anything until the criminal court plays its way out. That isn't true. Depending on what the scenario is in particular, our decision making is going to be different than the criminal context. We don't need to have beyond a reasonable doubt evidence, right? We don't need to have a criminal violation of a criminal statute in order to discipline someone for work purposes. So, for our standpoint, we likely will want to do our investigation anyway, so long as they're allowed to be involved and not incarcerated or something. So, you don't have the obligation to advise an employee of their union rep. If they ask for it, you have to give one. And we'll talk about the specifics of Weingarten in the next slide. But I'm one, I don't often like fighting over this issue. I usually will say, email them, set the meeting up, and tell them if they want, they should bring a union rep if they want one. And then let them deal with it, because then they can decide yes or no. The bigger, more important piece is, I think, addressing the union rep in this meeting, right? The union rep in an investigatory interview is there to make sure that you aren't violating the contract. And so what I like, they are not there to be their legal representative. They're not there to be their lawyer or pseudo lawyer, right? So I address that from the very beginning in an interview, especially if I have what I know to be an active union rep. And I say something along the lines of, your union rep is here. I just want to make sure that we all are on the same page and understand this is an investigatory interview. We as the employer are conducting this interview. This is our interview, and we're interviewing you. Union rep, no offense. I'm not here to hear what you have to say. You're not the lawyer, so I don't want any objections or testifying on behalf of the individual, or even asking questions of the individual. If there comes a time when you want to ask some questions, you let me know. But during the course of the interview, this is my interview, and I would like to conduct it, please. There will be no caucuses, by the way. This isn't bargaining, so no caucuses as well. We're going to conduct this interview and go from here. And then if the union rep won't abide by that and they keep interrupting or asking questions or trying to stop the interview, what I would basically say at that point is, look, we're trying to give an opportunity to due process, not to you, to them. And if you're going to keep interrupting, we're not going to continue this, because I don't want your opinion on this. I want to hear what they have to say. So if you want to do that, then we're going to forego this, but this is the opportunity for due process. Because what's important when it comes to due process is that we give them an opportunity, not even necessarily they give their side of the story, but that we give them the opportunity to do so. There is no obligation to give the names of other people or to give witness statements, right? So if you say to them, again, going back, to my understanding, I've been told this is what you said and this is what you did. They can't say, who told you that? Or they can say, if they say, who told you that? You're going to say that's not important. I'm telling you what I've been told. What is your position on it? And if you want, maybe give more facts to the context. I'm not going to tell you who, but here's a scenario. It's my understanding that this happened at a PD meeting last Thursday after the meeting was over, so on and so forth. There was a conversation, and in that conversation, you said this, this, and this, right? Give enough facts so that they can understand. You don't have to give names. You don't have to provide witness statements as well. When you're done conducting interviews, prepare your own sort of notes or statements, right? If you're not taking notes during it, sometimes I don't like taking notes during an interview because it hinders my process of having a conversation. I've done in the past where I've actually recorded them, and I've told them, I said, hey, look, I'm going to record this. This is just for our purposes. I'm going to use this for my notes, and then this won't be used for anything else. Or when you're done with the interview, right away, take your notes, talk, think about what they told, what the interview said, what you were told. So that way you have that and you have it down now, or record it or something, to be able to talk through it so you can summarize what was said. Because again, as we go on here, memories will change and fade. And if you're doing a big investigation with a lot of people, it can really change. Employee witnesses, if someone's not implicated themselves, still the rule again, you're the employer, you're asking them to sit for an interview. You can say that they must attend the interview. Again, you can't necessarily say that they must answer the questions, but they don't have a right to a union representative. However, if they ask, and if they didn't bring one and during the interview they ask, I always give them one, because under Weingarten, what it says is that an employee is entitled to have a representative at an investigatory interview of the employer if the employee reasonably believes that disciplinary action might result. So if they ask for a union rep and your response is, you're not in trouble here, well, you don't know what they have to say, right? And maybe they have something to say that could end up getting them in trouble. And so as a result, if they ask for a union rep, I say generally give it to them. The rule is they have the union rep of their choosing, unless it's going to unduly burden the investigation. So if they're in a union and they want their president, but the president is on vacation right now, we can say, no, pick somebody else, your building rep, anybody else. We don't want to decide for them who their union rep is going to be. Again, informing, you can try and keep it private, but you can't guarantee anonymity. Again, witness statements need not be supplied to the union as well, not just to the individual. So there's a good Michigan Employment Relations Commission case on this one that says you don't have to supply witness statements. However, if it's going to go to hearing, and they're going to be called, then you have to give the other side those statements in advance so they can have them and know what the person said. But you don't have to do it in particular during the course of the investigation. Ultimately, when we're doing an investigation, we have to make a conclusion, right? That's the point of doing so. Either that there are no findings that can be made, or, yes, this happened, or no, it didn't definitively, right? When you're doing that, again, use a guide, look to harassment policy or bullying policy, etc. Know if your CBA deals with the issue, because if your CBA deals with this issue or deals with investigations in general, you're going to want to know that and make sure you follow the CBA. You don't want to do a good investigation and then have it undermined in a grievance later because the CBA required something and you didn't do it, right? Whether that's providing a union rep, whether that's, giving due process within a certain amount of time, whether it's providing the initial complaint to them. Some of these things might be for example, CBAs I've seen oftentimes will say that if a parent files a complaint against the teacher, that the teacher will be provided with a copy of the complaint, right? So if you do an investigation on that parent complaint, but you never give that teacher the complaint, your whole investigation could get undermined based on that contractual language. So you need to think about that all the time. Okay, is the CBA in play here, right? The good part is we all have the CBA on the website. It's generally going to be in a searchable PDF format. So, if we're dealing with a complaint, go to the CBA and type in Control F complaint, right? Or look at an investigation, or do some keyword search to make sure that there's nothing that you have to deal with here. If you have nothing on point to guide you definitionally, use something that may not directly apply if you can, right? If two adults, if one is saying the other adult is bullying them and we don't have a bullying policy when it comes to our adults, only the kids, use the kid policy, right? And say, okay, we don't have a policy against this, but this is inappropriate conduct. And truthfully, using the bullying policy for students, this would be a violation of that policy if it were applicable, right? So use those definitions where you can to help guide you, to give you focus on what it is that I'm looking for here, or what I'm trying to figure out, right? Follow up in writing, depending on the complaint and its seriousness, the type of writing can vary from a follow-up email to a full investigation report. So, if ever you're in a situation where you're in a meeting, and in that meeting, you're giving an employee a directive of some kind or a warning of some kind, follow that meeting up with an email, right? Even if it's not a major thing, if you're meeting with them because they're not following your directives relative to what they're doing in the classroom, if you're meeting with them because they're having conversations with parents that are not really appropriate, right? Whatever the case may be, we're not disciplining them, but you've looked at a situation, you've talked to some people, you're having a meeting to say, this conduct is not appropriate. And I want you to think about that and act differently in the future. Follow up with an email, right? Because ultimately, if that conduct continues, it could become discipline, right? It could become something that is problematic, and you want to have that notice, that define, because if you later on, I can tell you this because I've sat through conducted a lot of arbitrations and a lot of hearings in my almost 17 years as a school lawyer. The reality is, when they get on the stand, you didn't tell them that. No way. Or if you did have that meeting, that's not what you said, right? So it's important instead, if we have just that email that says, hey, look, thank you for meeting with me in my office yesterday. I really appreciate your time. Just to go over again, here's what we talked about. Going forward, here's what you're going to do. Here's what I think is, here's what you're going to do, or here's what it's important that we do this or we do that, right? Having that is key, because then it summarizes what was talked about and what the directive was. And then later on, if it's violated, they have clear notice, right? Obviously, if it's a bigger issue, if it's leading to discipline, we're going to write a disciplinary memo. If there's a harassment or some complaint like that, we're going to have an investigation report of some kind. But in everything, and I know, it can get tiring hearing this from lawyers in particular, but the reality is documentation is so important. And it's not that, people will say, well, if it's not documented, there's no evidence. Well, no, testimony is evidence, but documents are evidencer. They're more important evidence because it shows something at the time. And the reality is, if you send that email and the person doesn't respond and say, whoa, wait a minute, that's not what we talked about, that's going to be important, right? Because that's their time to object to what was said. And if they don't, that means something. So it's really important. Keep a summary for your own purposes, for your own records as well. This is something that's important, just again, for your own memory and purposes, not just of the interviews, right? But just have an investigation summary. If you're doing it, any kind of a major investigation at all, just sort of type something up, even if it's just a Word doc that you have in your computer, because it'll help keep your memory fresh. And I think our case study will be a good example as to why, right? So this is a real world scenario that I dealt with in this case, it was a long time ago. I was a very young school lawyer. Situation was such: male and female teachers in an elementary school. The male teacher's been there for a few years. The female teacher is a first year with the district. I don't know if she's a first year teacher, but she was the first year with this school district and in this building, okay? Female teacher complains to the building administrator about her treatment from the male teacher. Principal speaks to both of those teachers, along with about 3 other staff members. about some of these conversations the two of them had, and some of the things that she's saying this male teacher was saying to her. She has those conversations. Ultimately, she meets with the male teacher, tells him to knock it off, that he's making her uncomfortable, and to stop it. It's not documented. Meets with the female teacher as well and says, hey, look, thank you for bringing this. I've met with him. I think he's gonna knock it off. If anything else happens, let me know. Okay. Never a document, no letter in the file, no discipline issued, no follow-up emails, anything like that. A year or so later, the female teacher transfers to a different elementary building in the school district. About a year after that, the district is having some financial issues. And so they're going to make the principal of the one building the principal over two elementary buildings, including the one that the female teacher transferred to. The female teacher stands up at the board meeting where they're considering this issue during public comment time and says, you're considering making this principal the principal over these two buildings. You should not do that. 2 years ago, I was sexually harassed. I told her I was sexually harassed, and she didn't do anything about it. So, record skips, everyone stops. They bring in the lawyer, and next thing you know, I'm doing a full investigation 2 years after the fact. And of course, the decision was happening at the June board meeting because it was for the next school year. So now I'm trying to conduct investigations of teachers during the summer. You can imagine how fun that was to try and get those investigations happening. And this was pre-Zoom world. And so, it took basically the whole summer to get this thing done. I end up in total interviewing almost 20 people when all was said and done because of the breadth of what the complaints were. At this point in time, the female teacher had now hired an employment lawyer so there's a threat of a lawsuit out there basically as a result of it. End up producing this 100-page investigation report. And really, the conclusion was there was no evidence that I could find of sexual harassment other than her now allegations 2 years later. And I couldn't tell whether or not those were true. There was no other evidence to substantiate them. But more than anything, what I was really ended up now doing was investigating the investigation, right? My job was to see if what the principal did in many ways was appropriate at the time. And the fact of the matter is, I don't think she did anything inappropriate. When I talked to her, when I talked to the others who were involved in the initial stage, everything they told me was, hey, look, she never said that she was sexually harassed. In fact, what she said, what she discussed was basically rookie hazing, right? They're both in the teacher's lounge and he's like, hey, newbie, you got to wash the dishes, right? Or these sorts of things. Mates would make comments to her, would make comments that maybe, again, were not professional, but were not overtly sexual. And she never raised the issue of sexual harassment. In fact, that's not true. Well, at one point, she said something about sexual harassment in a meeting with the principal and multiple other, like 2 or 3 other teachers who I interviewed. And the principal specifically said, wait a minute, you've never mentioned sexual harassment before. Are you saying that you were sexually harassed? And she said, no. But again, none of this is documented and there's no follow-up email about any of this, right? So if, again, just after that meeting with the female teacher, if she had sent an email that said, here was the complaint, here's what happened, and here's what we discussed. This individual is not going to, be in contact with you, so on and so forth. If you have any other future concerns, please let me know. Then maybe this whole process goes way easier because we're not in a scenario where even if she makes the complaint 2 years later, we now have this, documentation to show, wait a minute, no, I raised this issue and she didn't do it, right? So, in terms of that, an investigation summary or report of any kind would have been a huge help. All right, other sort of final investigation consideration, the more documentation provided, the easier it is to justify the decision now and later. Because, when things happen, when the complaint is made at a board meeting, it's 2 years later and memories are fuzzy, and that documentation helps. Even if, let's just say, it's an employee issue, an employee discipline, and we're getting to a situation where they file an EEOC charge or an MDCR complaint, or they file a grievance, and maybe that grievance goes to arbitration. For the last 12 years, if you've been a principal or an HR person, you could issue a discipline to a teacher and there would be no grievance and no arbitration because teacher discipline was a prohibited subject of bargaining. Well, that changes in February. So all of a sudden, because the law changed this year. So now, I've done some discipline arbitrations over the last decade, but I haven't done any for teachers. That's going to change, right? So if we get to that arbitration, that documentation is really going to matter because it's going to be a helpful thing for you in terms of presenting your case, proving your case when it comes down to it. And again, even if we can't use it in the case, it's going to help your memory stay fresh about what happened and what you did. Because as you all know, if you're a school administrator, today's fire might be huge and it might seem like you're going to remember that forever. But tomorrow we're going to have another fire. And then next week, there's going to be another one as well, right? So a lot of things are going to happen in between and our memories are going to get fuzzy. It's also easier to justify action in subsequent disciplinary situations. So this goes back to what I talked about before, right? Maybe we're not even taking discipline now. What I see oftentimes in my role as a school lawyer is that someone like Rebecca gives me a call and says, hey, Bob, I have this employee and they're bad and my principal now wants to fire them. And I say, okay, well, what's wrong? Now they've been a pain in the butt for years. And now this latest thing happened. Well, the latest thing isn't really enough to fire them over. But, okay, they've been a pain in the butt for years. Great. So what do we do about it? Well, we had some conversations. We talked to them a few times. Do we have anything how they've been evaluated? Oh, evaluations are always great, right? Do we have any documentation of those conversations? No, right? Well, now it gets a lot harder to fire for that last thing, even if they really have been a bad and or difficult employee for years, because that documentation, again, when it comes to that case, that arbitration, that tenure case, they're going to say, that's not what happened. That's not how it happened. You're lying. They're going to, all kinds of different types of scenarios. And so that documentation along the way makes life so much easier when we get to that end point. And we don't have to do it in a confrontational way always. We don't have to always be like hammering people. It's just about when something happens, we create a record of it, right? Another point I think is important is that the level of outrage or attention should not dictate either our course of investigation or our level of discipline, right? Something happens, an employee does something, we believe it's inappropriate, we give them a 2-day suspension. Next thing you know, our good friend Facebook blows up and it's all over the place. And as we talked about social media earlier, it feels like there's this black cloud now hanging over all of us because of this social media conversation. And then you call me and go, hey, Bob, we gave this person a 2-day suspension, but can we fire him now? The answer is probably going to be no. You made a decision. You got to stick by that decision, right? That level of outrage, because the pitchforks and torches are at our door, doesn't mean that we can now change our decision, right? We made a decision, especially at the final decision where we issue the letter, it goes in the file. Now we're not going to go back on it. And so, same thing, right? Something happens at our school. We haven't even done the discipline yet, but now there's a tension, right? And if there wasn't that attention, maybe we give a 1-day suspension, but now we're going to terminate. What's probably going to happen is they're going to be able to find some people who have done something similar and haven't been terminated. And that's going to undermine our whole case. So what I always say is, if you're making a decision, if you're going to discipline someone, whether that's a student, whether that's an employee, always assume it is going to get out, right? Make the decision thinking, okay, if this hits Facebook, if the Channel 4 news truck is in my bus loop tomorrow after this decision, am I good with it still, right? If Huel Perkins is talking about it on Let It Rip on Saturday, and they're dogging me about it, am I going to be able to say, okay, I'm good, right? Assume that from the start when you're making your decision, and always assume that's going to be the case, because I think that puts you in a better condition. It's still not gonna stop the emotions of the feeling of what happens when that's going on, but at least we'll know, yes, our decision is consistent and it's justifiable, either to the high end or to the low end, right? We're firing in this scenario, even though we might not have with somebody else, because of the history of this person, and that's okay. Or vice versa. This is a really good employee who made a dumb choice, and I'm not going to tank their career because of this one dumb choice, right? And so, let's be in that position. Don't prejudge your outcome. Any doubt, always go to HR with anything that you can. After all, that's their job. And as the one bullet here is, be thorough in making determinations. Never assume something is as simple as it is. All right. Shifting gears, Governmental Tort Liability Act. Again, this has been a real point of conversation, especially in our post-Oxford world, right? If you watched the press conferences that Ben Johnson or Jeffrey Feiger had when they announced the lawsuits against Oxford schools, this was what they were talking about. They said, look, the law right now, I think Feiger even said in his press conference, we anticipate that we are going to lose this case, but we're doing this to try and change the law, right? And so this is the law that they're talking about. And the reality is this is a really important law and one that we need to keep in place. And so I want you to know about it, because I want you to have some level of security, because this is something that we get fear of all the time. I just got a call 2 weeks ago from an administrator who said, hey, Bob, I have a high school principal who's telling his teachers that if a fight breaks out, they should not try to break it up, because if anything happens, they could be liable. And he says, I don't think that's right, is it? Should he be advising them of that? And I said, no, he's not right. And they shouldn't be advising them of that, right? Because the reality is the law protects us generally. So what are the protections? Well, first, the Governmental Tort Liability Act is a statute, so that's been passed by our legislature. It protects governmental employees and officials from tort liability. What is tort liability? Tort liability is when one person sues another person and the suit isn't based on contract. So it's negligence, it's defamation, it's any sort of lawsuit where one party is suing another and that lawsuit isn't based on a contract. There are some exceptions allowed, but they're rare. And generally, you're protected pretty well. And the higher up you go, the more protection there is. But some important definitions. We'll talk about a governmental function in a little bit. This is what a governmental function is. I'm not going to read the whole thing for you. But basically, it includes anything that you are either allowed to do by statute or required to do, allowed to do, or even that the law would imply that you could do. Those are all governmental functions for a governmental agency, unless you're going out completely outside the scope of what it is you're doing, right? What we call ultra virus acts, meaning I'm a school district and I'm starting a side business. And not even one to help train students, but one that we're doing to make profit, right? We're opening up a dry cleaning business just because we thought, I have a history in it, and this could be a good fundraiser for the school district. Well, that's outside the scope of what a school district does. That's an ultra virus act. Things that are associated with the dry cleaning business are not going to end up being protected, right? So that's what ultra virus means. A governmental agency includes a school district, so a school district is part of the protected individuals in here, and public school academies as well. All right, so the protections are basically two parts. First, in Section 7 of the Act, a governmental agency and the highest elected or appointed official are given absolute immunity, meaning no tort lawsuit can be sued or can be filed against them and continue unless it meets an exception, either by law or through the Governmental Tort Liability Act. And in the Act, there are 5 enumerated exceptions. But so for the school district itself and the superintendent, they have absolute immunity unless these are the exceptions. The big one here that we mostly deal with is what's called the motor vehicle exception. And that is school bus driver is driving a school bus and is negligent and gets into an accident and there's an injury as a result. The school district could be held liable for that because of the motor vehicle exception. Public building exception is another one. We have a school that's in disarray physically, and it's falling apart. We know that it's falling apart, and we don't do something about it. And then that defect in the building hurts someone, right? Sort of classic case on this one. There was a Court of Appeals case years ago with Ferndale schools, where they had a situation in an old school building that had a vestibule, an open air vestibule, and in that there was a flagpole. Flagpole had begun decaying. They didn't replace it. One day, kids are outside in this vestibule. The flagpole breaks, falls on a kid, and kills this little girl. And so then the question was this a building defect because it was a flagpole outside? Ended up, Court of Appeals decided yes, it was a building defect in that scenario, and that liability could go to the school district. So that's the kind of thing where a school district could be held in liability. When it comes to individuals lower than the superintendent, so basically everybody else who's either an employee or a volunteer for a school district, their protection is, I'm going to read this, and I apologize, it's statutory language, it's a little thick, but I think it helps. Except as otherwise provided, without regard to discretionary or ministerial nature of the conduct, each governmental officer and employee, each volunteer acting on behalf of a governmental agency, and each member of a board of a governmental agency is immune to tort liability for an injury to a person or damage to property caused by the officer, employee, or member while in the course of employment, or by the volunteer while volunteering, if the following are met. 1, the individual is acting or reasonably believes they're acting within the scope of their authority. The agency is involved in a governmental function. And then finally, the employee's action does not amount to gross negligence that is the proximate cause of the injury or damage. All right, so the main 2 things that we're thinking about here is, are they acting or reasonably believe they're acting within the scope of their duties? And 2, did their conduct amount to gross negligence That is the proximate cause of the injury. Well, what's gross negligence? Gross negligence means conduct that is so reckless that it demonstrates a substantial lack of concern for whether an injury results or not. I acted so recklessly that I didn't even care if what I did hurt people. Okay, that's gross negligence. And then the proximate cause is what it says in there. And what our Supreme Court has said is this means, by using the word the proximate cause and not a proximate cause, it means the one most immediate, efficient, and direct cause of a cause preceding an injury. So that's an important distinction, because in law school, when you learn about the phrase proximate cause, there's proximate cause, and then there's direct cause. Direct cause is what they're defining here, which is the proximate cause. A proximate cause would mean what we call but-for causation, right? And but-for causation is I'm sitting here in my office and I grab my mouse and I throw it through the window behind me. The window breaks and shatters. Another lawyer in my office is walking down the hall. He steps on a shard of glass. It goes into his foot and it causes an injury. Okay. Now, I wasn't the direct cause of his injury. The direct cause of his injury was the shard of glass on the ground. But I was a proximate cause. I was but for causation, because but for me throwing my mouse through the window, that shard of glass wouldn't have been there, and that lawyer wouldn't have gotten injured, right? So that's a proximate cause. The court says when the legislature used the word the, they meant the proximate cause, meaning the direct cause. And so what we see in a case like that is, here's an example. This is a case that we handled in our office years ago, a case called Parent versus Lapeer Community Schools. In this case, we had a student A, we'll call him. Student A has brittle bone disease. As part of that, student A is confined to a wheelchair. He's in a motorized wheelchair. His IEP requires paraprofessional support for 4 to 6 hours a day, including that para escorting him in between classes, carrying books, going to his locker, supervision during phys ed, supervision during outdoor recess, etc. Okay. Now, again, IEP says 4 to 6 hours. The way it worked was, kid got off the bus, came into school, met the parapro. The parapro was there basically the whole day. Parapro would take the kid to 6th hour. And then once the kid was in 6th hour, the para was done for the day. Okay. Now, kids in 6th hour, there, of course, the way it has to work in these scenarios, there's a long-term sub in the class at the time. Kid comes to the teacher, him and his friends say, hey, we're done with work for the day in this class. We're working on a project together. Can we go down to the computer lab and work on this project? Long-term sub says, yeah, as long as there's an adult in the computer lab. There's not an adult in the computer lab, then you need to come back here. They say, okay. They go down. There is, in fact, an adult in the computer lab, and they stay there. They're working. The student with the wheelchair is at the computer table. His friend reaches to the keyboard, comes back. His sweatshirt gets caught on the joystick of the student's wheelchair. The wheelchair like lurches forward, hits the table. The keyboard stand drops, falls on the kid's legs. He has broken legs because he has brittle bone disease. Family sues and says that long-term sub was grossly negligent, and as a result of their gross negligence, there was an injury, and she's responsible for it. And what the court said here was, no, that is not the case. One, the teacher was not grossly negligent. Sending them down to the computer lab while making sure that there was an adult and making sure that they stayed together was not something that is gross negligence. That's not conduct that's so reckless. And the family would say, the family's lawyer says, well, wait a minute, no, but they needed to have a para. the para is supposed to be there for transitions and going to all these other places. And they say, yeah, but even the IEP doesn't require the para to be there anymore. It's 4 to 6 hours. It doesn't say to go to the computer lab. It's still a classroom at that point. So no gross negligence. But even more importantly, even if there was gross negligence, the court says, the teacher was not the proximate cause of the injuries. The cause of the injury was that computer table falling on the leg. So maybe at most, the direct cause was the student's sweatshirt getting caught on the joystick, right? That's the cause that created the problem, not the teacher allowing them to go down there. And so this was the same thing. If you saw in the news a while back, the first of the Oxford cases was dismissed at the Oakland County Circuit Court. It hasn't been decided by the Court of Appeals yet, but it was dismissed. And this was the same reason why, because what they said was, okay, you have arguments about whether the counselor should have checked the backpack or what they should have done with the parents, or should the kid have been allowed in school that day or some other day, or whatever the case may be. But none of those, even if we assume them to be gross negligence, which again, I haven't seen any evidence that shows any of those actions were gross negligence, but even if they assume them to be gross negligence, the proximate cause of the injuries to the kids was the kid with the gun, right? So it's important to know and understand that as long as we're acting in good faith, and I'll get to the good faith part in a minute here, in our duties, and we're doing what we're supposed to do, and we're not being reckless, the law is going to protect you from a liability standpoint. In fact, with the law, the Governmental Tort Liability Act even says is that it doesn't change the law of intentional torts as it existed before the law was passed. Intentional tort means something that you're alleged to have done intentionally, right? And not just I acted negligently and then something happened, but I intentionally defamed you, or I assaulted you, or something along those lines, right? This is where what they say is, as long as the employee's acts were undertaken, again, within the scope of their duty, or if they reasonably believe they were acting in the scope of their duty, and they were taken in good faith, then they're protected by the law, right? So my phone call and our example of the teacher who's breaking up a fight, right? If I'm a teacher, 2 kids are fighting, and I come in and I separate the 2 of them, and when I push them apart, the kid stumbles and hits his head on a locker, right? I'm not acting grossly negligent. I'm trying to break up a fight. I'm not acting in bad faith. It's not an assault, right? These kids were in a fight. I was trying to keep peace. Now, if I break it up and I pin the kid against the locker, and then this kid's always been a pain in the butt, so I get a couple of shots into his ribs while he's there, now I'm acting outside the scope of my duty. Now I'm acting in bad faith. But so long as I'm acting within my role, I'm acting reasonably or responsibly, I'm not acting grossly negligent, right? Then I'm going to be protected by the law, and I'm going to be prevented from having to have liability. It doesn't mean they can't still sue you. Okay, this is a question I was getting. Bob, how do we stop them from suing us? You can't. Anyone who has a $375 filing fee can file a lawsuit, right? They can make up causes of action. They can say things that aren't true. Anyone can file a lawsuit, and we can't prevent them. But they won't win that lawsuit unless the person is acting grossly negligent and it's the proximate cause of the injury, or they're acting with bad faith and outside the scope of their duties when it comes to an intentional tort. All right. Last topic for the day, grievances and grievance processing. So first, what is a grievance? It's important to know this, because if you're an administrator and you're and you oversee any employees, you're going to be involved at some point in the grievance process generally, right? Maybe you're step 1, maybe you're step 4, you're involved. So what is a grievance? Can anything that an employee or the union doesn't like be filed as a grievance? Generally, no, right? A grievance is generally a violation of the collective bargaining agreement, right? A grievance is part of the collective bargaining process. And in order to file a grievance, generally, it has to be that's a claim that you violated the contract somehow. Now, it's important to know that your grievance procedure will define what a grievance is. So go to your grievance procedure and look at it. Especially, once you receive that grievance, before you respond, before you have a meeting, look at your grievance procedure. The grievance procedure is going to define, and it'll say something along the lines of a grievance is an alleged violation of this contract or the express provisions of this contract. It might say something like the express provisions of this contract or a practice thereunder. It might say something like a grievance is an alleged violation of this contract, comma, a practice thereunder, comma, or board policy. We don't want that language in there, but if it's in there, you need to know it. So the contract will define what a grievance is. So look at your contract, know what it is. It can't just be, I'm upset about something. It has to be related to what the grievance procedure would allow them to grieve. In terms of the importance of handling grievances effectively, well, why is it important? Because effective grievance handling can produce a favorable results, right? It can improve your chances of winning the arbitration. It can potentially solve the problem if you're handling it better. It can lead to more positive labor management relationship. Even if it goes to arbitration, sometimes handling a grievance properly can still have better labor management relationship because it shows consistency in your actions. It shows that you're going to do things a certain way, and it at least gives the boundaries of how this is going to go, right? It can also increase the probability that the union might choose not to go to arbitration if things are done possibly. So eventually, what's important to understand too, in terms of both the process, when it comes to the grievance handling and the investigation and the like, is process under the contract is really important. Because when the grievance happens, oftentimes the grievance is not necessarily going to be related to the final decision. It's going to be related to process. And what I say here, right, is the dirtier the grievant, the more focus will be on the procedural handling of the act or the grievance by administration, right? Again, if we're talking about a teacher who's been negatively evaluated, we haven't had to deal with that in grievances in a long time, but we're going to have to probably start pretty soon because, again, that prohibited subject is going away. So we're going to see grievances about the evaluation and the evaluation process. Or if there's a discipline and there was an investigation, if that person did it or they're bad, they're not going to try and disprove necessarily this person's a bad employee from the evaluation. More likely than not, what they're going to try and show is you violated procedure under the contract. And because of the violation of procedure, the conclusion is illegitimate and we can't get there. So this is why I say, again, when we go back to the investigation piece, look at your contract, know your contract. Same thing when you're then doing the grievance processing. Did you violate that contract along the way? If you realize you did, that's going to impact your response on this grievance and how you're going to react to it. So what can you do in this process? Okay, again, know your language, know what's in there. Contracts have peculiar language sometimes. Even now, a lot of this stuff might have been removed because of prohibited subjects, but it's probably back in some appendix somewhere, and they're going to try and bargain it back in the next round of bargaining. So know about this and understand it and look at that language, know what you're dealing with, right? You can be sure that your union rep is going to know about those details. And they probably aren't going to tell you about it because they're going to hold that card in their back pocket if you're violating. Maybe they'll say, hey, whoa, you're violating the contract right now. But maybe they won't. Maybe they'll just hold on to it, or they'll use it after the fact. Do some research. If a grievance is filed, just give a call to HR and say, hey, I got this grievance. Let them know about it. Ask if if there have been any grievances about this before, or look into it at all. Is there a MOU on this topic that we don't know about that's hiding out there somewhere that's not appended to the contract that we have to think about? Or some of these things might be hard to find, but try and figure out, is this an issue that we've dealt with before or not, right? If it's a discipline issue, have other employees been disciplined for the same issue? If so, what did they get? And are we going to do the same or around the same or different this time, and be able to explain why, right? If language has changed recently, that can be really important, right? An example here on this one, had a school district where we had contract language that said if a bus driver tests positive for drugs on a random test, they have certain results, but they don't lose their job right away, right? They get put on probation, they have to go through a substance program, so on and so forth. That language is bargained out of the contract. The very, very next school year, we get a teacher who gets a random and test positive, in this case for cocaine. And the district's or the union's response is, well, wait a minute, all of a sudden now we bargain this language out and you're going to an automatic discharge? Well, no, it's not an automatic, it's cocaine. It's a pretty serious situation here, right? And so, but that removal of that language, that bargaining of the language, was a big part of the conversation in that arbitration and in that grievance process. So you need to know about that when you respond in terms of that process, right? Again, always talk to HR before you give your response to the grievance. Coordinate that process through them so everyone's on the same page. It may be very important, and if the case comes to me, I might not be able to have the time or the ability to look into that history and that sort of a thing, okay? Review your CBA, make sure that other provisions don't apply as well. There might be something that we're dealing with here that actually is addressed in another provision of the contract, so try and figure that out. Again, do word searches, look at your table of contents and say, okay, is there anything else that might apply to this issue, right? We're talking about leave time here, and is there anything else? So understand your grievance as well. If your CBA requires that the union put down what provision of the contract is being violated, the article and section, and they don't do it, tell them that they need to do that. That's what the grievance procedure requires, right? If it doesn't require that, but the statement is vague, it's okay to ask for clarification. If the grievance has a meeting associated with any step, my opinion is always have the meeting. The meetings are where you're going to potentially solve grievances. You're not going to solve them in the written grievance and response. The grievance and response is what you use to set the process for the arbitration. The meetings are where things actually get done, okay? So if there's a meeting, have it. My suggestion is use those meetings to ask a lot of questions. Make sure you fully understand what the grievance is, why they think this is a violation of the contract. What about this situation? What about that situation where we've done this in the past? Use that opportunity to ask those questions. Because this is your only time. A lawsuit, you have what's called discovery, where you can do depositions and you can do all that stuff. In a grievance, if we're going to arbitration, we don't have that. These meetings are our chance to really ask them questions about what it is that they're claiming is a violation of the contract. Because ultimately, when it goes to an arbitration, they have to show that this is a violation of the contract. They're going to have some burden there to show that. And so we're going to run ask those questions to know exactly what they're claiming so that we can address it when it comes time. I'm a believer that you don't write lengthy grievance responses. Sometimes they can be helpful, so long as they're not. So long as it doesn't end up having anything that sort of trips you up along the way, and things can trip you up along the way, right? Another reason is it's rarely effective, at least internally. Maybe it'll be effective to the arbitrator, but ultimately the arbitrator is going to want to have a hearing, and they're going to want to hear the facts, and they're going to make a decision on those facts that they hear at hearing, right? It sets up your argument for them and shows maybe some consistency, but they're not going to care about that most of the time. They're going to want to know what they hear in the hearing. The union rep is never going to go, oh, you're going to read your response and go, you know what? You're right. I shouldn't have filed this grievance. We're done now. I've never seen that happen in almost 20 years of doing this, and I probably never will over the course of my career. So, that's not going to be the reason to do so. What probably is more likely going to happen is you're going to box your lawyer into an argument, and limit me from making other arguments that I see in the contract because you didn't raise it. You gave a specific answer, and now I'm stuck, right? And it may give you may show your hand to the union and give them an opportunity to come up with sort of workarounds during the process, right? Their grievance might change a little bit from step 1 to step 2 to step 3 because of your lengthy grievance responses, as they're sort of getting smarter and trying to expand their grievance because of the fact that you've now shown your hands. So more often than not, my recommendation on a grievance response is simply no violation of the contract, grievance denied. There are a few topics, however, that we need to include specifically in our responses if they're applicable. That would be one, what we call arbitrability, or whether this thing can be grieved and taken to an arbitrator. So if the contract limits, for example, if it says, hey, discipline for a probationary employee can be grieved, but only taken to step 3 and not step 4, which is the arbitration step, then make sure that's raised. Because when we go to arbitration, we're going to say, Mr. or Mrs. Arbitrator, you don't have any authority to hear this case. There's no jurisdiction because the contract said so. Another one is timeliness. An arbitration is generally going, or a grievance is going to generally have a time frame by which it must be filed, and then each step along the way what must be filed. If the union wasn't timely, if they had to have filed a grievance within 10 days of the occurrence and it's been 15 and they file it, say that it wasn't timely, that may be a good argument at the arbitration. But if you don't mention it in the grievance responses, then the arbitrator generally won't consider it. They'll say, well, no, you didn't consider that. You denied it based upon the contract language, not upon the timeliness. And so I'm not going to rob myself of jurisdiction now. If there's a prohibited subject of bargaining, which more than likely there won't be anymore after about February. But if there is a prohibited subject of bargaining, state that, meaning in the last 12 years or so, for example, teacher placement was a prohibited subject of bargaining. So if the alleged violation had to do with teacher placement, we'd say, no, that's a prohibited subject, you can't grieve it. A couple last important concepts: unequal treatment. We talked a little bit about this before in terms of treating one person differently. That can be a winning argument at arbitration. And it might be something you'll see in the grievance. Hey, my person is being treated unfairly. In this case, it doesn't even necessarily have to be based upon a protected classification. It can just be, you're picking on my guy. If we've given this person a different level of discipline than somebody else, we need to be able to explain why. And we're going to be able to do that before. Due process, again, We can't issue discipline without giving the person an opportunity to address the issue that we came to. And then finally, double jeopardy. This goes back to our outrage thing, right? I gave them 3 days. We put a letter in their file, and now we're terminating them for the same acts. That's not going to work. If something else happens, and then we want to go to discipline and we include the fact that the earlier disciplines occurred, that's okay, but you can't discipline them twice for the same thing. So I was able to finish about 7 minutes early here. If there are any questions, we have some time. If anyone has anything that they would like to ask, I am happy to address it. Okay, if not, thank you all very much. I really appreciate your time, and hopefully this was helpful for you. If any questions come up later on, and you want to email Rebecca or someone else from M&A, I'm sure they can forward those along to me. So thank you.
Thank you, Bob. This was, as always, informational, and I learned something new. So thank you so much. And thank everybody for coming.